going to discuss whether you're a yoga studio owner or a teacher. COVID has changed how the entire yoga world operates. It's more important than ever to have the best legal practices in place to ensure your business and assets are protected. And of course, we're joined by our good friend and special guest, Cory Sterling from Conscious Counsel. Before we jump in, I'll give a little introduction for the both of us here. So I'm Joe Fagan. I am the Director of Strategic Partnerships for beYogi. And of course, here at beYogi, we offer membership programs for yoga instructors, yoga therapists, and other health and wellness disciplines. Our membership packages provide liability insurance, business and marketing tools and resources, as well as member benefits and industry discounts for yoga professionals. Programs provide access to group rates on dental and vision insurance and telemedicine, as well as a concierge service to find low-cost health insurance options. And since we're seeing more and more yoga instructors move their business online, of course, I'll mention that our program covers not only face-to-face classes, also live online classes, and even pre-recorded videos. Remember, we do these webinars the first and third Wednesday of every month, or we've been doing them the first and third Wednesday. Keep a look at that schedule. Sometimes it changes. But please keep joining and please keep sharing these events with your community. If there are any topics of interest to you, let us know. And again, we keep building these programs based on those surveys, based on the wants and the needs of the beYogi community. So please keep them coming. This video of this webinar will be posted on the blog on beyogi.com. And on there, you can also find the schedule of upcoming events. Now I'd like to introduce you to our very special guest, Cory Sterling. So Cory Sterling is a lawyer, a small business owner, a group fitness instructor, and yoga teacher. He wrote the Yoga Law book and has served hundreds of clients in a health and fitness space all across the world, the majority of whom own or operate a fitness or health studio. He's presented at conferences around the world, teaching about the law in a fun and practical way. He won the award for the highest rated session at Mind Body Bold in 2019 amongst a field of health and fitness leading minds and best presenters. In March of 2020, he completed the Mind Body Business Consulting Program in order to learn the overall best business practices for studio, and is the only lawyer to hold the certificate. Love that. And one last thing, we'll be answering questions as we go along, but we'll also save 10 to 15 minutes at the end for additional Q&A. So submit any questions that you have in the Q&A or the chat, and any questions that we can't answer today, we'll do our best to get answered and to send out to everyone after the event. And now I'll hand it over to our good friend, Cory Sterling, to kick things off. Welcome, old friend.
Joe, thanks, brother. It's wonderful to be here, and hello to the whole beYogi community. We've got about 50 minutes to have some really productive discussions about the law, how it applies to yoga professionals operating online in 2021 in a COVID world. And the point of all of it is that this is going to be fun. So the reason why I continue to do these webinars and I continue to operate my legal practice is that I see there are so many yoga professionals who think that the law is super overwhelming or intense or confusing or heavy. And really what our mission at Conscious Counsel is to make the law accessible, make it informative. And what I want is for yoga professionals to feel supported in the way that they're working with the law. So just like a small little paradigm shift of taking, a traditional topic that has been so heavy and confusing and challenging, and really letting you know, hey, it's actually pretty simple how all of this operates. So my one goal more than anything else from doing this talk is that I want to give you practical information that you can apply to your yoga businesses today. So that's it. Everything that I'm sharing with you is rooted in the practical elements of it. And I'm going to stay away from the super theoretical aspects of law. Like, I don't want that discussion. I don't want you to take a nap. I want you to, feel good and be like, okay, this is my business. And this is one thing that I can actually do and take with me today. So that being said, as we start, I want everyone to keep in mind, I know that we received one question beforehand from a woman who runs a yoga studio in Texas, and I'm going to be sure to answer that question specifically. But my request of everyone is, if I'm saying something and it triggers something in your mind where you're like, whoa, I would love to ask a lawyer who understands the yoga industry a question right now, please do it. Like, please, 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 please. Firstly, I love answering questions. Typically, I'm I always get asked the same question, so it makes it easy to answer them. Wink, wink. So I feel I feel good about that. But also this is really your opportunity to understand the practical aspects of how law applies to your business. And I just want to be able to answer as many questions as possible. As well in the chat, if everyone, I brought an apple to this little talk. This is my snack. If everybody wants to open the chat and just share either something that you're eating that's really tasty or something tasty that you had in the past 24 hours. I love food. Like, I just feel more comfortable when food is around. Yogurt and Cheerios is great. I'm eating an apple. That's what I'm writing. Ginger cookies, vegan burrito. Yeah. It's also, I can't look at all the things in the chat because then I'm only going to talk about food the entire time. But I just want all of us to sort of feel comfortable and be comfortable with food. So that being said, Joe, I'm going to do a little bit of an introduction about the practical elements of what I'm seeing my clients and the industry going through right now, and some super helpful tips. And then as I'm speaking, if questions come up, I'll be happy to address them. And then we're just having fun. That's all we're doing today. We're just having fun. Does that sound good?
That all sounds great, Cory. There was in the Q&A a question that came in that I think is relevant simply because I think it's from Babs, and I think she's wondering whether this is going to be relevant for her. So if you don't mind, I'd like to throw this question out to you. Before I do that, I do want to mention in the chat, Mary Kay, I appreciate you qualifying your answer there. She originally put beer juice and changed it to beet juice, I think from a typo, but I was going to ask you because that seemed very interesting. What was beer juice? Anyway, sorry about that. So Cory, Babs Freeman simply wrote, is this information relevant for teachers in the UK?
Yes, it is. We at Conscious Counsel, we have global clients all over the world, and the general legal principles that I'm discussing apply to United K common law. So the answer is yes. And also what you're going to see, and I think that's a great transition, Babs, that I just want to explain to everybody. Really, as a lawyer, what my job is, you're not going to believe me, but I'm going to tell you. As a lawyer, most of what my job is helping clients communicate their expectations openly and honestly in the various commercial relationships they have. So really what law is a tool. And if you're a health wellness professional, if you do dance, if you do movement, if you do mindfulness, if you do meditation, if you do yoga, if you do fitness, if you do sports, all of this is relevant. What I'm talking about here is the general approach of how we as online wellness professionals need to think about the law and apply it to our businesses. So Babs, what I want you to get from this conversation is that firstly, it does apply to you, and B, as a lawyer, again, just to reiterate, most of what my work is working with clients and helping them realize what sort of relationships they want to have in their business. So I wrote this book called The Yoga Law Book, which you can find on Amazon. And in the book, I basically say to all of the readers, hey, law is really just a series of relationships. And the goal in each of those relationships is to communicate your expectations openly and honestly. So for example, if we take a document like a waiver of liability, a waiver of liability is a document where someone is signing away their legal right to bring an action against you. And in order for it to be effective, you have to effectively communicate openly and honestly all of the activities that you're doing, all of the risks that you're doing, and what the outcomes of those risks are. And I'll go into more detail because I see a question just came in about waivers. So I'll make sure to spend a good chunk of time about waivers. But I understand everyone comes in and they've got questions and you want to know all of the things. But what I'm trying to, in a practical sense, I'm trying to progressively explain to you how you need to use the law. And you're going to say, Cory, why should I listen to you? How do you know? And this is the answer. Firstly, we've got hundreds of clients who work in as yoga professionals, both online and with studios in person. You can believe me or not, but I'm going to tell you the truth. 99% of the issues that I have to resolve as a lawyer deal with some form of misaligned expectations between two people. Whether it's a studio owner and a teacher, whether it's a teacher and a client, whatever sort of relationship it is, whether it's a studio owner and a landlord, all of the issues that I have to deal with, or that I see in our industry that I have to deal with and help resolve, all of them deal with a misalignment. There's a missing piece between what the parties thought they were getting into in terms of a relationship from the start. And so that's why before I go into the difference between a contractor and employee, or the importance of using a trademark, or the importance of waivers of liability and how it works, before I get into all of that, what I just want to share to all of you in a practical sense, the best thing you can take from this conversation is evaluating the different relationships you have commercially in your business and thinking, how can I communicate my expectations openly and honestly with whoever I have that relationship with? So give me a thumbs up if that makes sense. Cool. I see one thumb up from Joe, which is great. But again, this is practical. I don't want everyone to take a nap. I don't want you to be disinterested. We're talking about the relationships that you have and using legal documents to communicate openly and honestly in them. The last precursory topic that I want to talk about is resolving issues if they come up, and how you're going to want to do that, and practically how it works. So in a practical sense, what I see one of the biggest misunderstandings being for yoga professionals and the law is they don't really understand how, if an issue arises, how it's going to get resolved and what that process looks like. So again, before I get into the specifics about the law, I just want to explain this to you, because once you have this piece of information, you can reverse engineer what you need to have in place to protect you and your business. So a typical problem that will happen that I help resolve as a lawyer, there's an issue between two parties, and one person will either hire a lawyer and send what we call a demand letter, or will write an email themselves and say, hey, I signed up for a membership and I really don't like it and now I want my money back. Or they're going to say, hey, I was doing your online class and I really hurt my neck after we did handstands and now I can't go to work anymore, so you have to pay the damages for that, right? Just to explain so everyone knows how the process works and why it's important to have documents in writing. Someone makes a complaint to another person. At that point, let's say you receive the complaint. Someone says, hey, I was in your studio and I had this problem, or one of your teachers harassed me, or this, that, whatever it is that the complaint is. At that point, you're going to have to respond to whatever the complaint is. And the strength of your response will dictate how long, intense, stressful, expensive the process of resolving the issue is going to be. If someone makes a complaint and you have a legal agreement that person signed, and in the agreement, it directly goes against what their complaint is. So I want a refund. I signed up for a membership. I want my whole annual membership refunded to me, even though I enjoyed 4 months of the services, right? You have a membership agreement. It clearly states the expectations of the parties in working together. You can just send them a screenshot of that agreement that everybody signed and say, hey, remember, this is what you agreed to. Here's a copy of your signature for the document. Therefore, you have no legal claim against us. And then it goes from like being stressful, being concerned, being worried, having to hire a lawyer, to just being resolved in 10 seconds. And then you can go on, building your business, doing Instagram ads, doing whatever things make you happy. Conversely, when you don't have the appropriate legal structure in place or the appropriate legal documents in place, and you receive a complaint from someone, whether it's a contractor who wants to be an employee, whether it's someone who got injured and didn't sign a waiver of liability, whatever it is, trying to resolve an issue without legal documents takes so much more time and is so much more stressful, and just it prolongs and extends a really crappy situation, so that then your focus is engulfed around that problem instead of like, okay, whoa, pushed it aside and now I'm free moving forward. Instead, it's like walking through quicksand and like walking through mud, and it just takes your time, and then you can't sleep and you're worried, am I getting sued? What's going to happen? So the liberty and the freedom I want for all of my clients and for everyone listening here today is to have awesome relationships, to communicate your expectations openly and honestly, and have written support for the relationships that you have, so that in the event something comes up, you don't have to waste your time you know, resolving a situation with someone who's causing problems for you, and instead you can just like circumvent it and go forward. So that being said, thank you for listening to that. I hope that resonates. And the reason why I share it again is because I want yoga professionals to know how law really works, and that the easiest thing that you can do to practice proactive law is to have the agreements when you start your relationships. So that being said, the first question that I saw come in, and Joe, I'm going to start with waivers of liability, and then from there, if anyone else has any other questions, we'll get started. So the question that I saw come in had to do with, you know, speaking about online waivers of liability, and I'm happy to do so. So the reason why an online waiver of liability is really important, it's the same reason why a waiver of liability for something being done in person is really important. And that is when you are facilitating an experience or hosting someone for an activity or teaching someone in a yoga class, the law automatically says like, okay, well, if you're teaching somebody something, you have a responsibility to make sure that person is going to be safe in practicing that activity with you, right? So especially even if you do a donation class, you still have an obligation at law to make sure that person will be safe. But also if you're doing it for pay and you're a certified teacher, you have a responsibility to make sure that someone's going to be safe. So the reason why a waiver of liability is so important is that it is the document that someone uses, that you use, and you have someone sign that says, hey, I'm going to be participating in this activity with you. And normally, you know, I would be able to hold you legally responsible if anything happened to me while we were doing this activity. But because you've communicated to me openly and honestly the risks and the activities, and I'll go over the elements in 1 second, because you told me exactly what I'm doing with you and what the risks are and what the outcomes of those risks are, I accept that I'm participating in this voluntarily, and that I'm healthy enough to participate, and that because you clearly told me everything we're doing together, I release you of all liability. I will not sue you if something happens to me. It's a free world. You've communicated openly. I made the choice to participate knowing what the risks of these activities are. And as such, I cannot hold you legally responsible. And even though normally you would be legally responsible, because I've signed this agreement, you are no longer responsible. That's the general idea of a waiver of liability. Now, the reason why online waivers of liability are different is because they pertain towards activities that are performed online. And it's very, very important that your waiver of liability, if you are offering services online, it has to specifically state that the services are being provided online, and things like you are not able to ensure that it is a safe space where the person is practicing, because you can't always do that. And also that people have to be more careful because you're not able to provide adjustments or observe as people are doing these things live and in real time. So while I was writing the yoga law book, while I was writing that book, I did a lot of research on waivers of liability. And what I discovered is the instances when a waiver of liability will not apply are when the waiver of liability was not clearly drafted. Almost every case where a waiver of liability was thrown out or proven to be ineffective was because they looked at it and they're like, well, actually, you know, the waiver of liability didn't specifically address that these people would be doing this particular activities the way they were doing it. And as such, it's not fair to have them sign away their legal rights if they weren't properly informed about what they were doing. So the reason why online waivers are different is because the activities of what you're doing have changed. It used to be that you offered yoga teaching in person. Now you're offering yoga teaching online. And as such, if you want to use your old waiver to apply to a new situation and a new way that you're performing your services, if I was a lawyer hired to challenge that waiver of liability, I would very easily be able to do so. And I would say, well, look, my client signed this piece of paper, but it didn't say anything specifically about things being done online. And as such, it should not apply. And my client never signed away their rights legally. So what I want everyone, if you've got a pen and a paper, this is a good opportunity to write down what the elements of a waiver of liability are. So the first thing a waiver of liability must have, it must specifically state what activities are being done. So it could be online yoga, it could be online acro yoga, it could be in-person yoga, it could be yin, it could be nidra, it could be ashtanga, it could be kids yoga, it could be prenatal. Whatever it is, you want to make sure that the waiver of liability captures the specific activities that you're doing and the specific ways that you offer those activities. So the first is activities and the way that those activities are offered. Number two is, what are the risks of those activities? So we're going to be doing acro yoga. What are the risks of acro yoga? That I could fall, that I could get someone's toe in my nose. Has anyone gotten a toe in the nose doing acro? That happened to me once. I'm not a big toe guy, so it was a bit of a traumatizing small t experience for me. But if you're doing something like acro, the second element you need to write is, okay, what are the risks of these particular of the activities we're doing? And then the third element is, what are the outcomes of the risks? So if I'm doing bird pose in acro, or I'm doing acro yoga, and then I fall on my neck, the outcome of that risk of me falling from 3 feet onto an area possibly without a mat could be, spinal cord damage, permanent injury, permanent change to quality of living, diminished earning capacity, all of those things. And those are the three elements that I want everyone to make sure it has. So those are, what are the activities and how are they performed? Number two is, what are the risks? And number three is, what are the outcomes of those risks? The other elements a waiver of liability needs to have is, once you've told people exactly what you're doing and how you're doing and what the risks are and what the outcomes are, they then can say, okay, you've told me everything. I now voluntarily choose to participate in this activity. As well, they can say, you've told me everything we're doing. I can also affirm that I'm healthy enough to participate in these activities in this particular way, which is also really important to do. And then lastly, they get to sign away their legal rights and say, I release you of any liability that may come from me. So just one final time, I'll try to speak as slowly as I can, all of the different elements of a waiver of liability, and then we'll open up to questions if there are. Number one is, what are the activities and how are they performed? Number two is, what are the risks? Number three is, what are the outcomes of those risks? Number four is voluntary participation, understanding the activities, risks, and outcomes. Number five is affirmation of health, that someone is healthy enough to participate knowing all of this. And then number six, finally, is the waiver of liability. So I'll take a pause. I'm going to have a bite of my apple. If you're drinking beer juice, this is a good opportunity to drink beer juice. And Joe, if there's any questions, I'm happy to deal with them.
Yeah, thank you, Cory. Great stuff. And a couple of questions did come in, so I'll just throw them at you as you're eating your beer juice. All right, so here, and you already did a great job, Melissa Seigel asked you to please discuss online waivers, which you've done. Thank you so much. Corinne, I messaged you before that you and I can chat after, because you asked about loans as a part of the policy. Corinne did also ask, what is the best waiver for YouTube channel for yoga mindfulness videos?
Okay, great. So I'm happy that you asked about YouTube, because there's a distinction that I need to make with everyone about a waiver of liability and a disclaimer, or a social media disclaimer, or a YouTube disclaimer. So the way a waiver of liability works, it's like the waiver of liability is the gold standard. And it's the best protection you can get, because a waiver of liability is a document that someone signs or electronically agrees to, in which they forfeit their right to bring a legal action against you. So done, signed, it's over there. The reason how you're able to administer a waiver of liability is in a situation where you know who is participating in the activities with you, right? So if we think traditionally it was the front desk of the yoga studio, in 2021, we think about maybe it's the Zoom waiting room, or giving someone the invite to our access to our online studio. We know we're giving them access, we're letting them in, we can make sure that they sign the waiver of liability beforehand. A disclaimer is different, because a disclaimer is where you do not have control or the ability to monitor whoever is consuming your content. So that relationship at law still exists, where you are facilitating an activity for someone, and you are doing so via content you are posting on YouTube, on Instagram Live, on Facebook Live, on whatever method that you're using to do it, but you're not able to administer those people or make sure that they sign waivers. So the next best thing is like the waiver of liability's little like kid sister would be a disclaimer, which basically says, hey, you are doing these activities at your own risk and you will not hold us responsible, and these are my qualifications, and all of those sorts of things. It's not as good as a waiver because someone is not legally agreeing to that by participating in the activities, they do not hold you responsible. But it is sort of like the safety net that a trapeze artist, what's it called when they hold that really long stick and they walk on a tightrope walker? Yeah, it's sort of like the safety net of a tightrope walker, where it's like, okay, it's going to save you. It's not the best thing that we've ever had, but it is something that is better than nothing. And so what you want to do is, if you have YouTube videos dealing with mindfulness or yoga or whatever it is, it's always good to have a YouTube disclaimer that you include in a description of the video, which would say something along the lines of, don't quote me, and this isn't legally what the answer is, but hey, we understand you're doing this activity. These are our qualifications. Only do so if you're healthy. Only do so if you, voluntarily respect your body, don't push it, and all those sorts of things. So the distinction we're talking about is between a waiver, which is the gold standard for someone signs, and a disclaimer, which you use, which is like, it's sort of the best next thing, which you use when you're unable to control who is consuming your content. I hope that's helpful.
Great. There's quite a few more questions, Cory, if you want to keep going down this path, or I don't know if you want to.
Let's roll.
Okay. All right. Next one and I think there's quite a few questions on this topic, so it's probably a good transition into, from Arthur Banks mentioned, is there a specific language around COVID which should be included in waivers?
Thank you very much for the reminder. I think I sort of focused on the online element as opposed to COVID, but COVID needs to be included as well. So if you remember, I said that a waiver is as good as the activities and the risks that it describes. With COVID, what's happening now is we're doing the same activities, we're doing yoga, but if we're offering the services in person, there's also a communicable disease that is going around that is invisible, that we can't really control, and that is very difficult to monitor how it is, how transmissions are made from one person to the next. So COVID should be included in the waiver of liability because the activities are different. The activity is different is that we're not just doing yoga, we're doing yoga in an environment where there is a communicable disease that is being transmitted, however it is being transmitted. And as such, because that activity is different, the risks of the activity are different as well, because now we're not just doing yoga, we're doing yoga in an environment where there's a communicable disease. And as such, the risk is, you could sprain your ankle, you could sprain your wrist, you could sprain your neck, but it's also possible that you catch this communicable disease, which could have, very challenging effects on your life. So COVID needs to be included in the waivers of liability, so long as what you're doing has any in-person element to it, and it should just have it anyways. And the way that we draft waivers of liability at Conscious Counsel is like, we draft the waiver so that it covers COVID, that it covers online, in person, and all the different types. But to answer your question specifically, yes, COVID specifically should be addressed, because remember, the activity is different and the risks are different. So the document needs to make sure that we capture that.
Thanks, Cory. Great stuff. Quite a few more questions here, and I can continue down the path. There is one I just want to jump in here. Lindsay Smith had asked a specific question about beYogi, and I was trying to type it and answer it, and I think I kind of messed up, so I just want to make sure this gets out there. She wrote, also, beYogi told me that I don't need a waiver of liability for online yoga because the policy covers it, so I haven't been given one out. Is that not true? And I just wanted to address, you're correct in that we do not, beYogi doesn't require anybody to use a waiver of liability to enroll in our insurance. It's not a requirement that we have, though. We highly recommend it. And again, that's why we're bringing Cory on to give this information. Some insurance policies do require that you use a waiver of liability. Our program does not. highly, highly recommended that. I just want to make sure that was addressed before I moved on to the rest. And then real quick here. All right, so back to the questions. Angela wrote, "Hi, my yoga school is currently offering donation-based yoga classes via Zoom. Since we don't charge in advance, we put the Zoom links on our website so anyone can join freely. We have a waiver statement on the website right next to the links. Is that enough to protect us?"
No, ideally, and look, everything I share comes from best legal practices, and it comes from working with hundreds of professionals. Ideally, if you are giving people access to your Zoom, really try your best to collect email addresses, and then you can use something that's called Waiver King or other services. But posting a waiver next to where the link in, remember, that's a very different lower standard than someone signing, electronically agreeing to be bound by an agreement. So wherever possible, you get the signed agreement done. That's the priority.
Perfect. All right, shall we keep going there?
Yeah.
All right, so next question comes from Janelle. There an expiration date on these waivers of liability? The studios that I work for do not have a date on these types of waivers/forms.
Okay, so that's a great question. And one thing you want to make sure for the waiver of liability, you can draft it so that it includes a provision which says something like, so long as our activities do not change or your health does not change, the validity of this waiver will continue to inure until, full stop. You can sign the waiver one time and it will continue to apply. The only caveat around that is, remember, the waiver is only as good as the activities that it describes. So if you were doing everything in person and you didn't, because then you're doing things online, once you change the activities, you need people to re-sign activities. And I get that it's challenging. I was working with a client last week who has a studio of 175 members. And now she's finally coming around to getting all of her online documents sorted. And she's like, well, do I really have to get all of my clients to re-sign a waiver? And my answer is the answer that I'll give you now. If the waiver accurately captures the activities that you're doing and how those are operating, then you do not need to change it. But once you change the activities, or once there are different or new activities or risks, at that point, you need to update the waiver of liability. But otherwise, it won't expire so long as the activities are the same.
Perfect. At least one more. So Kathy wrote, and I think I see oops, sorry, that's not the next one. Samantha Richardson had wrote, and I see a few people have asked this too, and that is there an updated online waiver we can use? So we have put a templated waiver on our site. So in our member portal, if you enrolled in our insurance, you have access to our member portal. There's an online template waiver there. But this was all born and bred from our discussions with Cory, and I just want to be very clear. An online templated waiver is no solution. It's a good starting point. And I'll certainly let Cory kind of fill in the dialogue there. But at the end of the day, filling out the specific information, bringing it to legal counsel, having them review it, making sure you have all your points in there are crucial steps to this. But there are online templates in our member portal. Was that accurate, Cory?
Yeah, well, Joe. Yeah, Joe, you did great. This is what I'll say about using customized legal agreements. It's sort of like, and I'm going to try this analogy. Everyone, just stick with me. It's sort of like going hiking and with shoes. And I had this idea. I hiked Kilimanjaro, which was a really cool experience. And it's sort of like having a waiver of liability that doesn't fit your business, especially because if you realize everything I'm talking about is how specific it relates to your activities in your business and what you're doing. Just having a general template. Firstly, if someone's hiring me to challenge a waiver of liability and I'm challenging a waiver of liability that's a general template, it's very easy for me to do that. And so remember, the first thing I said is you want great agreements so that in the event an issue comes up, it's strong enough that you can deal with the problem or issue right away. The more specific a document is tailored towards you and your business, the better it will support you in the event that you need it. And legal documents are like seatbelts. You don't need them until you need them. But when you need them, you want to make sure that you have a seatbelt that really works. And so the whole idea of the shoes, it's if you're going climbing up a mountain, you need a pair of shoes. But having someone else's shoes or, wearing the same shoes that everyone else wears won't help you and your feet because your feet are different and they're more specific. And to get to the top of the mountain, you're going to want something that specifically fits you. I have especially wide feet, and I think that's the most personal piece of information I'm going to share with everyone today. Joe, you seem shocked to learn that I have wide feet, Joe.
I was more shocked about the hiking Kilimanjaro. I think that's pretty amazing.
It was, and I had my own shoes.
Oh, all right.
And I'm happy somebody laughed. I try to do these things with humor, but it's yeah.
Good stuff. We did have an anonymous attendee throw out a question. I think that's relevant here. And it's, he wrote, I have a small studio, he or she wrote, I have a small studio that is run out of my home for individuals with developmental and intellectual disabilities. I currently have all classes online. I hope to reopen at some point for in-person classes. Can I legally require students and their care providers to wear a mask? And can you require students and caregivers to have a COVID vaccine or disclose if they've had it?
Okay, that's the first part of the question. Firstly, that's a really valid question. Anonymous, lovely to meet you, by the way. I don't know the answer to anything vaccine related yet, because the way the law works is like things happen and then after time, it takes Congress or, our governmental bodies time to pass the relevant laws around how we have to behave. So the one thing that this is the only thing that comes to mind. The one thing you want to be careful about is discrimination or human rights violations, right? So not letting someone participate in a yoga class because they have not had a vaccine. I don't think there's a great exposure to risk about a discrimination case, but someone could say that they're being discriminated against as a result for that. I also believe that if for you, it's really, really important to have people wear masks before they're participating in your yoga class. I think you can tell them and their caregivers that that's something that is required of them to do. And look, the one, just coming back to the whole practical piece and how I want everyone to think about the law, right? Let's take Anonymous's example and think about, okay, where is the legal issue going to arise? So we have a studio and we say, we only permit people who wear masks and only people who've had vaccines. The only issue you run up against is going to come from someone who does not want to wear a mask, someone who has not been vaccinated, and someone who has a really big problem with both of those things. And that's why when you have customized legal documents and you can use the documents as a preface to let people know what type of relationship you want to make and how you want to make it, it makes it a lot easier. So you could have an agreement which says, hi, the reason why we have these policies is because safety of our community is more important than everything else. And we feel that we will only operate if we know that everyone has, been vaccinated or wears a mask. And if someone's going to get really, really upset at you because of that, because you're trying to create a safe space for the community, I feel like it's less of an issue because you're letting them know that it's sort of for an altruistic and communal means. And all I mean to say about that is use the documents as a tool to communicate why you're making the decisions you make and why you're behaving the way that you do. So I hope that's helpful. Joe, I see I've got about 10 minutes. I want to talk about trademarks and I want to talk about contractors and employees. Is that cool?
Yeah, no, that's perfect. We'll if we have an opportunity to answer some more questions at the end, we will. But everybody remember there's a lot of questions that are coming in today. We'll make sure that after this is over, if we haven't gotten to questions, we will get these questions over to Cory. We'll get answers. We'll get them all out to you. So your questions will not get ignored.
Okay, cool. And the reason why I just want to shift topics is because there was a specific question that came in beforehand. So in the future for everyone, two things. One is before we do this, when you see that we're leading a legal webinar, feel free to send your questions beforehand because I think those questions sort of always get priority. And then also I know that Lizzie's going to be posting, we have a free online course that we're offering to beYogi policy members. That's this is the surface level what we're doing for everything. If you want to go through the online course, I think it's about 9 hours or so. You can learn about all of these issues more in depth in a really helpful way. So that's a free resource. I want people to know about the law. The question came in from a studio owner in Texas who said, in the state of Texas, they're currently cracking down on the distinction between contractors and employees. And I'm really worried about having my teachers be contractors because I want to make sure that I want to make sure that they're not misclassified either as contractors or employees. I feel like my screen just froze.
Looks good on my end, Cory.
Okay, cool. Then
Uh-oh, now you froze. Not sure if he's frozen for everybody out there.
Welcome back. I'm here. I'm still here. Hear me, Joe?
Yes, yeah, you're good.
Okay, cool. So the answer that I'm going to give, I looked into this issue, and I'm going to give an answer specifically for the state of Texas. But there are different, the general rule of a classification between a contractor and employee varies from state to state. So for example, California and Massachusetts are two examples of states where they have a very, very strict test between the difference of a contractor and employee. Other states like Florida go by the general IRS test of a control test, and Texas is the same. So to answer the question, and I'm sorry, I forget the studio owner's name who wrote the question, but the question was, okay, contractors, employees, you know, am I going to get fined by the government? What happens if I'm not doing things the right way? The question will always come down to what control you have over the people who are working for your studio. So the more control that you have over the way the services are provided, the more that they are an employee, and the less control that you have over the way the services are provided, the more they are like a contractor. And that's like the general overarching provision. One reason why it's really helpful to work with a lawyer is because lawyers understand specifically
Uh-oh.
Hi, Joe, we're back.
All right. Yeah, you froze for just a second, just a minute there.
Yeah, sorry about that. So the one thing that I want everyone to know is it always comes down to the degree of control over the services, and that working with a lawyer is helpful because when you work with a lawyer, they understand what the legal tests are based on the jurisdiction, and they can help you reverse engineer the way the services are provided so that the relationship, in fact, is one of contractor and employee. But to our studio owner in Texas, just a couple of general legal points for you to know. One is that it doesn't matter what you call the relationship. So let's say you have contractors and you get them to sign contractor agreements. If the way they're providing the services is that of an employee, then it doesn't matter what you call it because you're not the one who gets to decide what type of relationship you have. The way that the relationship will be determined is
we seem to be having connectivity issues here.
a distinction. The first is the first has to do. Oh,
you're good now, Cory.
Cool. The first has to do with scheduling. Like these are just the general things that they'll look at. Scheduling. So does the contractor choose their own hours, or do you set the hours for the contractor? Invoicing. Are they paid automatically, or are they paid only when they invoice you? Do they earn more money based on better performances that they provide? Scheduling performance. And then also the way that the services itself are provided. So like, do you say, okay, if you're doing a yoga class, you always need to teach it in this particular way? Or if you give them free reign to do whatever they want, all you're doing is teaching yoga, however that happens, go ahead and teach. That's another distinction. So there's, unfortunately, it's a complex legal issue, but the thing to know is that A, it doesn't matter what you call it, and B, it has mostly to do with the way that the services are provided. So it can be really helpful for you to work with a lawyer, and in doing so, the lawyer will be able to help you achieve the type of relationship you want to have, and make sure that the services are being provided to you and your business based on that. And then the last thing that I sort of want to touch on just before we come to the 10-minute window for Q&A to wrap everything up, just has to do a little bit about trademarks. And that's where we've seen a lot of our clients really needing support in the last while. The reason why intellectual property and privacy policies and operating online is more important now than it was before is because we see yoga professionals who have communities that are outside of the area where they live. It used to be, okay, everyone, all of my clients are just here in my neighborhood where I live, and I know everyone, and we went to high school together, and everyone comes in. But now, because everyone's offering their services online, where we see yoga professionals who have clients from all over the United States and all over North America. And a byproduct of that is like, there are more eyeballs on your business now than there ever were before. And there are more people who are looking at different yoga businesses and being like, oh, well, like, that's a cool name, or I like this, or this is really cool, or maybe I'll take that logo, or I'll do that sort of thing. So we've seen an increase in that just because of the way that consumer behavior has changed around the sheer volume of clients from so many different places. So when it comes to a trademark, the important thing is registering a trademark to secure your brand. If you've got a business name, making sure that your business name is secure. If you've got a logo, making sure your logo is secure. If you've got a slogan, making sure your slogan is secure. And I just share what I've been through with a bunch of clients at the end of 2020 was seeing them have to change their business name because they didn't register their trademark. And the thing that you have to know is the first rule is the person who's been using that mark, a particular mark, the longest has the best priority. But once someone registers for a trademark, that automatically puts them above the person who was using it longer. And then it's an uphill battle. It's like you're swimming against the current in order to fight to be able to use your business name and have exclusive use over it. So I just wanted to share that. I see we're at the 10-minute mark. So I'll pause there on trademarks, and I'm happy to answer any questions that might have come through for anyone. And I'm here for you all.
Perfect. Well, I'll just go down this list. I don't think there's a chance that we'll get through all of these questions, and that's okay. Again, we'll send as many answers as we can post a webinar communication. But I'm just going to go kind of consecutively back through the questions as they were sent in. All right, so starting at the top here, and it looks like there's a couple of questions on this topic here, so I'll throw this one at you. Kathy Geyer, and I see that Stephanie's T wrote a very specific question. It's, I need more info on number 3. How exactly how detailed must these be? And what they're talking about is the outcome. In fact, Stephanie wrote, how specific do you have to be about outcomes? Can you touch on that?
Yeah, for sure. So the way that you want to think about it, everything I do in law is reverse engineering. So start at the problem, start at what the issue is going to be, and then how can we come up with a process to make sure that we're covered for that potential outcome. There's not like a definitive answer about how specific you have to be, but just think about what the outcomes of the risks potentially are and whether or not your document accurately captures what those outcomes of risks are. So that if someone got injured and if any of these risks were actualized, looking back at the document, would you be able to say to that person like, well, hey, like we told you your quality of living would change, or that, you could experience, pain or long-term physical damage, right? Like think about what could go wrong. And just imagine a situation where someone's saying to you, like, hey, I got injured and now I want to sue you, or this document wasn't good enough because it didn't raise this relevant issue. And what you want to think about as the one with the document is, well, actually, I'm sorry, that's incorrect because we told you A, B, and C. So it doesn't have to be like super, super amazing specific, but it just has to be enough to rebut someone else saying, well, like, you didn't tell me that my quality of living would change, or that I could die, or that this, that, or the other. And you just want to be in a position where it's like, hey, like we did tell you that this could happen, and it did happen. And because we told you before and you still agreed to participate, you cannot hold us liable. So unfortunately, there's not a granular specific answer. There's sort of like an art to legal drafting, but the answer is, think about someone complaining to you or suffering an injury, and then look at the document and say, would the document cover me in case that happens? And I hope that's helpful.
Thanks, Cory. Another one from an anonymous attendee. Do you recommend having a client intake form on top of a liability waiver, or is this unnecessary for online classes?
Yeah, the thing, I mean, the question is what's going to be included in the intake form, but my answer would be yes. At Conscious Counsel, we draft something that's called a client service agreement, which is an agreement that goes through all of the specifics about how the services are going to be provided and who's doing what and anything that you need to expect from them or what they can expect from you. But I usually say, like, the more communication, the better, to make sure that everyone feels they're communicating openly and honestly. If the intake form, excuse me, if the intake form specifically has to do with previous injuries or health issues or whatnot, that's totally your choice of whether or not it's something you want to include. But I like my clients using a client service agreement because, again, it creates the relationship openly and honestly. The expectations of both parties are communicated very clearly in a document, and that's the best way to start the relationship.
Amy had wrote, and I think I can answer this. Should we have an attorney create this? And I'll pass it to you, Cory, but I think the answer is yes.
Yeah, you want someone with experience in this industry. The reason why we specialize in working with yoga professionals is because it's like we understand specifically how yoga operates, how the classes work, what the activities are, what the risks are. Having an attorney look at it is always helpful to have a professional helping you with anything. But the more that an attorney understands the specifics of your business, the better your legal documents will be.
We kind of touched on this, but there's a couple of questions that came in about signatures. I'm going to run them both by you because I think they'll both answer this potentially with the same answer, a single answer. Peter Turtle Wolf wrote, what is the best way to get a legally binding signature for online classes? And then a second similar question came in from Kimberly McClure that wrote, what does the online signature for a waiver have to look like? Those are a little different,
so it's obviously it's 2021. And so an agreement can be bound electronically, digitally, and someone can be bound to an agreement in a couple of ways. One can be like with one of those electronic signatures that they place in a document. It can also be that before you give someone access to your online studio or to your Zoom link or whatever, they have to click, I agree to be bound to these terms and conditions. And so that's the answer for both of them. But the one thing to know for both of you who asked this question, you want to make sure that the agreement explicitly states that you accept online signatures. It's like one of those old, like, crappy traditional rules about law, which there's a lot, but you want to make sure that the agreement explicitly states, like, we will accept online signatures, or clicking I agree is the same as if someone were to sign by hand. So those things, in addition to either an electronic signature or someone clicking I agree, will suffice.
And Lindsay, who's written a couple of great questions here, she wrote, and I'm not sure we have time for this, and maybe this is for a different session. Can you please discuss website legal issues before the session is over, i.e. privacy policy and terms and conditions? Is there any quick snippets that you can provide? Or
I'm going to do it in 1 minute. That's my promise to you. So when you collect personal information at law, you need to have a privacy policy to let people know how you collect that information. If I were to go through the specifics of a privacy policy, you would take a nap right away. It's like one of those hypnotic tricks where it's like, let's talk about the specifics. But all that you need to know is that it's a compliant element of the law. So you have to make sure that you're following what the relevant rules say and that your privacy policy deals with all of those issues. You can work with a lawyer. You can work with us to get a privacy policy. But if you collect personal information or you do online transactions, it's important to have it. Terms and conditions are really important as well, because those are the rules of someone operating on your website. So you want to have provisions about copyright. You want to have cancellations. You want to have refunds. And basically, in the event that someone interacts with something, either a product or service or information on your website, and an issue arises, you want your own customized terms and conditions to be able to deal with that issue directly. And that was just over a minute.
That's perfect. All right. And another question that came in, and by the way, I may I may mispronounce this name. By the way, I see Kathy Geyer had thanked me for pronouncing her name right. I luckily got one right there, but I do want to say if I've mispronounced anybody's name, please, I apologize. That is not my strong suit. But Aruna, Aruna P wrote, just putting a disclaimer in our Zoom invite will be sufficient to protect the online yoga teacher?
No, a disclaimer is not sufficient to protect the teacher, but a disclaimer is better than nothing. You want a waiver of liability, Aruna. You want someone to sign away their legal right to bring an action against you. Remember, the disclaimer is it's less effective. It's not legally binding. It's like the small safety net for the tightrope walker at the carnival who's super high up and will fall down into it. Like it will or may do something, but it's not as good as a waiver of liability.
Yeah, perfect. Thank you. An anonymous wrote, not to be cheeky, genuinely asking, but then do we need to list all communicable diseases that are possible to be contracted in an in-person setting? Of course, referencing the need for COVID language.
No, my answer to that, and I get that it's a real question. I would say no. I would say no, that you don't necessarily need to. But again, just be reasonable, just so everyone knows, like, law is always about how reasonable you were, how reasonable someone behaved. And if like, you don't have to put every possible disease, like, oh, there's the flu going around and there's like, I don't even know any other communicable diseases, thank God. But you don't need to list absolutely everything, but like COVID is so obvious and trite that like, obviously that should be included. Not including COVID would be unreasonable. If there's other diseases going around and it's super, like, you can use your discretion of whether or not to include them. And I hope that helps. Aruna.
Well, that's great. I know we're bumping up on the 2 o'clock time frame here. I didn't know what your timing looks like. We can, I have a couple more questions we could throw your way if you have a minute or so.
We'll go for another minute, but just in the meantime, if everyone had fun, maybe you can just write the word fun in the chat. I had fun. I'm super passionate about law. I hope this information is helpful. And obviously I try to do it in a lighthearted, easy way because I want everyone to have the best practical information. So there's a lot of fun going on, and let's get the last question. And I think also Jake is going to post a link if anyone wants to book a consultation. If based on hearing this, it seems like you'd like legal agreements or to work together, feel free to book a call with us. But otherwise, Joe, let's hear the last question.
Last question I have, and again, there's many more, but we will address those post webinar. Corinne had written, I teach yoga on Zoom. Should I get signed waivers, and is it different from the YouTube waiver?
I teach yoga on Zoom. Should I get online waivers? Yes, 100%. So have an online waiver. Now it's okay. So it's sort of like, now we've had this conversation. You understand the importance that if you're teaching, to have someone sign a waiver for online yoga. And please give them, for all of the email addresses, do not let anyone access your Zoom link until they've signed a waiver of liability. That's the best practices. That's the best that I can do for you. So thanks again for having me, Joe. I love being here. I love all of these questions. It's such a professional, engaged community, and we'll make sure that we answer all of the questions that you got. And otherwise, just keep on keeping on, right?
Keep on keeping on. No, really, really appreciate your expertise, Cory. I mean, clearly, just by the amount of questions, this information is so important to this community, and your expertise lends such an important piece to this. So, just very much appreciate it. I know this is 3 or 4 times that that you've lended your time and expertise to our community, and we can't thank you enough for that. And if there's anything, we will get, of course, all these communications over to you, and just look forward to if we get a chance to do this again, Cory. And make sure you stay safe and stay on that, have fun on that kiteboard.
I will. I'm going to head out for a session now, but lovely to see with everyone and be together. Genuinely, I say the world needs yoga now more than we ever needed it before. So keep helping your community, keep providing awesome services. If it's donation, if it's your career, whatever it is, help people breathe, help people connect with their bodies. And let's continue to make the world a better place each day.
Perfect. Thank you, Cory. And thank you guys all for joining. Really appreciate it.